You're driving home. Normal day. Then you see it. Red and blue lights in the mirror. Your stomach drops a little. You pull over. The officer walks up. He asks one question, and what you say in the next 10 seconds can steer the whole stop. Every day, thousands of drivers make one critical mistake. They think talking helps, but the law does not reward being talkative. It rewards knowing exactly what to say and knowing exactly when to shut up. I've analyzed over 500 traffic stop cases. I've studied Supreme Court rulings, and I've identified 4 exact lines that can end a traffic stop in under 2 minutes. Miss one phrase, and you can hand an officer legal permission to search you, to detain you, to stretch the stop out. Use all 4, and you walk away protected. So let's break down the 4 mistakes and the 4 exact phrases that stop cops cold. Mistake 1. Answering, "Do you know why I pulled you over?" The mistake. The officer walks up. He asks, "Do you know why I pulled you over?" Most people guess. They explain. They admit. "I think I was going a little fast." "Was I speeding?" "I didn't see that stop sign." Congratulations. You just confessed on camera, before the officer even told you what he saw. The scenario. You're driving. Speed limit is 35. Lights flash behind you. The officer approaches. Body cam is recording. He asks, "Do you know why I stopped you?" You want to seem cooperative, so you say, "Was I speeding?" The officer smiles. "You were doing 48 in a 35. Maybe you were. Maybe you weren't. It doesn't matter. You already admitted you knew you were speeding." Why people do it? People think being honest makes them look good. But officers are not your friends in that moment. They're investigators gathering evidence. That's the job. Legal reality. Salinas versus Texas. 2013. The court ruled you must explicitly invoke Fifth Amendment protection. If you answer, you've waived your right. Your admission becomes evidence. Body cam shows you admitting to speeding. The prosecutor plays that clip. Case closed. Evidence problem. Body cam's record words. And when you say, "I think I was speeding," that's the confession. Your words undermine your defense. The officer didn't need radar. He didn't need anything else. He has you saying it. Officer psychology. Officers are trained to ask this. It's tactical. Most people will admit something. Either way, the officer wins. The correct move. Here's line 1. "No, officer. That's it." Calm. Polite. Clear. "No, officer. You're not being rude. You're protecting yourself." "No, officer." If they follow up, repeat it. "No, officer." Why it works. This forces the officer to state the reason on the record. You haven't admitted anything. You protected yourself legally while staying respectful. Body cam shows you were polite, but you didn't hand him evidence. Bottom line. Never answer, "Do you know why I pulled you over?" with anything other than, "No, officer." Every other response is a confession waiting to be used against you. And that's exactly the Fifth Amendment self-incrimination issue the Supreme Court addressed in Salinas versus Texas. But the Fifth only protects your right to remain silent. It does not protect you from physical searches. That's where the Fourth Amendment becomes critical. Because mistake 2 is handing officers permission to bypass the Fourth entirely. Through one simple word, mistake 2, consenting to searches. The mistake. The officer finishes writing your ticket. You think it's over. Then he asks, "You don't mind if I take a quick look in your car, do you?" Most people freeze. They don't want to look guilty, so they say, "Sure, go ahead." That one word just waived your Fourth Amendment rights completely. The scenario. You're pulled over for a broken taillight. The officer comes back with a warning, "No ticket." You're relieved. Then he asks, "You don't mind if I look around?" You hesitate. If you say no, won't that seem suspicious? So you say yes. The officer searches everything. Glove box, center console, under seats, trunk. 20 minutes later, your car is tossed. He finds nothing, because there was nothing. He leaves, and you're sitting there thinking, why did I agree to that? Why people do it? People think refusing makes them look guilty. They think saying no will escalate things. They think the officer will get a warrant anyway. But here's the truth. If the officer had legal grounds to search, he would not be asking permission. He would just do it. When an officer asks for consent, It's often because he does not have probable cause. He's fishing, and you don't have to help. Legal reality. The Fourth Amendment protects you against unreasonable searches, but you can waive that protection. The moment you say yes, you've done exactly that. Courts say voluntary consent eliminates the need for a warrant. If you give permission, the search is legal. Consent means the officer can search everywhere, and if he finds something, you're responsible. Evidence problem. Once you consent, everything discovered is admissible evidence. You can't challenge it later. Body cam shows you agreeing. That is your Fourth Amendment waiver on video. Officer psychology. Officers know most people will consent. They're trained to make no feel wrong. You don't mind, do you? Wrong. Refusing consent is your constitutional right. The correct move. Here's line 2. I do not consent to searches. Say it clearly, calmly, firmly. I do not consent to searches. If they push back, repeat it. Don't argue. Just state your refusal. Why it works. This puts the burden back on the officer. If he wants to search now, he needs probable cause. He needs legal justification. He cannot rely on your permission because you did not give it. And if he searches anyway, you created a record. Body cam shows you refused consent. That gives your attorney grounds to challenge the search later if it was illegal. You're not being difficult. You're protecting yourself. That protection is your constitutional right. Bottom line, never consent to a search. Ever. No matter how innocent you are. The correct answer is always, I do not consent to searches. That protects your Fourth Amendment right against unreasonable searches. But refusing consent does not automatically end the stop. Officers can still detain you if they have reasonable suspicion. That's Terry versus Ohio. And this brings us to a critical distinction most people don't understand. The difference between a voluntary encounter and a detention. Because mistake 3 is failing to clarify which one you're in. Mistake 3, not asking, am I free to leave? The mistake. The officer hands you your ticket. You sign it. He walks back to his car. But he doesn't drive away, he just sits there watching. You're not sure what to do. Are you free to go? Should you wait? Should you ask? Most people just sit there, uncomfortable, not wanting to seem rude. But every second you wait without asking is a second you're voluntarily extending the stop. The scenario. The officer gives you a speeding ticket. The stop should be over. But instead of leaving, he stands by your window asking questions. Where are you headed? Where are you coming from? Have you had anything to drink? You answer because you think you have to, because he's still there. But here's the question most people never ask. Am I being detained or am I free to leave? Without that question, you're stuck in legal limbo. You don't know if this is voluntary or lawful detention, and that uncertainty works entirely in the officer's favor. Why people do it? People assume the stop continues until the officer says otherwise. They think they have to answer every question. They think walking away would be rude or illegal. But there are 3 types of police encounters: voluntary, Terry stop detention, and arrest. In a voluntary encounter, you're free to leave. In a Terry stop, the officer can briefly detain you with reasonable suspicion. In an arrest, you're in custody. Most people don't know which type they're in, and officers exploit that confusion. Legal reality, Terry versus Ohio, 1968. The Supreme Court ruled officers can briefly detain someone if they have specific facts suggesting criminal activity. But the key word is briefly. Rodriguez versus United States, 2015. The court ruled officers cannot prolong a traffic stop beyond the time needed unless they develop reasonable suspicion of another crime. So once the officer writes your ticket, the legal justification ends. If he keeps you without reasonable suspicion, that can be unlawful detention. Evidence problem. Body cams record everything. If you sit there answering questions for 30 minutes without asking if you're free to leave, the footage makes it look voluntary. That undermines any claim of unlawful detention. The prosecutor will argue you never tried to leave. But if body cam shows you asking, am I free to leave? And the officer says, no, now you have proof. Proof you wanted to end the encounter. Proof the officer prolonged it. Officer psychology. Officers know most people won't ask if they're free to leave. They count on that silence. Some give vague answers. Just a few more questions. Almost done. Those are stall tactics, and they work because most people don't push back. The correct move. Here's line 3. This clarifies everything. Am I free to leave? Ask it calmly, respectfully, but clearly. Am I free to leave? If the officer says yes, thank him. Roll up your window. Drive away. The stop is over. Don't stick around. If the officer says no, you now know you're detained. At that point, invoke line 2, I do not consent to searches, and add line 4, which we'll cover next. I plead the fifth. Why it works. This puts the legal burden on the officer. If you're free to leave and he says yes, the stop ends. If not, and he says no, he has to justify why. And if he can't, your attorney can challenge the detention as unlawful. But only if you ask the question. Bottom line. Always ask, am I free to leave? Don't assume. Don't wait. Don't guess. Ask directly. If the answer is yes, leave. If no, stay silent. That question clarifies your status under Terry versus Ohio, and it helps protect you from an unlawfully prolonged stop under Rodriguez versus United States. But there's one more constitutional protection you must invoke explicitly, and it's the most misunderstood right of all, because Salinas versus Texas established that staying silent is not enough. You have to affirmatively claim the privilege. And mistake 4 is thinking silence alone protects you. Mistake 4, staying silent without invoking the fifth. The mistake. The officer asks a question. Have you been drinking? Where are you coming from? Do you know there's an odor of marijuana? You don't want to answer, so you stay quiet. You think silence is your right. You think remaining silent automatically invokes the Fifth Amendment. But the Supreme Court ruled otherwise, and your silence can be used against you in court in certain situations unless you clearly invoke the right. The scenario. The officer asks, have you had anything to drink tonight? You don't answer. You just stay quiet. He asks again, sir, have you been drinking? Still no answer. Why won't you answer? What are you hiding? You remain silent, thinking you're protected. But weeks later in court, the prosecutor plays the body cam. Ladies and gentlemen, when asked if he'd been drinking, he refused to answer. His silence shows consciousness of guilt. An innocent person would have simply said, no. The jury sees you on screen, silent, uncomfortable, and they think, if he had nothing to hide, why didn't he just answer? That's the problem. Silence without invocation can look like guilt. Why people do it? People think silence is automatic protection. They think the Fifth Amendment means you don't have to say anything. They think staying quiet is the same as invoking the right. But Salinas versus Texas changed that. The court ruled you must explicitly invoke the Fifth Amendment. Silence alone isn't enough. You have to say the words. Legal reality. In Salinas, the defendant voluntarily went to the police station. He answered questions for an hour. Then the officer asked if his shotgun would match shell casings at a murder scene. The defendant went silent. At trial, the prosecutor used that silence as evidence of guilt. The Supreme Court said that was allowed because he did not expressly invoke the privilege. Justice Alito wrote, in essence, that a witness who wants the protection has to claim it. If you want the Fifth Amendment to protect you, you have to say so out loud. Evidence problem. Body cam footage captures your silence, and without explicit invocation, that silence can become evidence. The prosecutor can argue, he had every opportunity to deny the allegation. He didn't. That tells you something. Juries buy that argument. Because to a reasonable person, if you're innocent, you just say so. Silence looks suspicious unless you explain why you're silent, and the explanation is invoking the Fifth Amendment. Officer psychology. Officers know about Salinas. They know silence can be used against you if you don't invoke. So they keep asking questions. They push. They probe. They wait for you to either answer and incriminate yourself or stay silent and look guilty. Either way, they win unless you invoke. The correct move. Here's line 4, and this seals your legal protection completely. I plead the fifth. Or, if you want to be more formal, I invoke my Fifth Amendment right to remain silent. Either version works, but you have to say it out loud. I plead the fifth. If the officer keeps asking, repeat it. I plead the fifth. Don't explain. Don't elaborate. Don't add anything. Just invoke and stop talking. Why it works. This explicitly invokes Fifth Amendment protection. Now, your silence is legally protected in the way Salinas talks about. The body cam shows you invoking the Fifth. That's your shield. That's proof you weren't being difficult. You were asserting a constitutional right. Bottom line, never stay silent without invoking the Fifth Amendment. Always say the words, "I plead the Fifth." That explicit invocation is the key piece that protects your silence from being used against you the way the Salinas decision allows when you don't claim the privilege. Here's the truth about traffic stops. They're not conversations, they're legal interactions, where every word you say can be used against you. The law does not reward people who talk. It rewards people who know when to stay silent and how to protect themselves. Same mindset I teach new shooters at the range. You don't wing it. You run a simple, repeatable process. Because when stress hits, you fall back on what's practiced. Let me give you the 4 lines one more time. Memorize these. Practice them. Because the next time you see red and blue lights, these 4 phrases can end the stop in under 2 minutes. Line 1. No, officer. When asked if you know why you were stopped. Line 2. I do not consent to searches. When asked if the officer can look in your car. Line 3. Am I free to leave? When you're not sure if the stop is over. Line 4. I plead the Fifth. When asked questions you don't want to answer. 4 lines. That's it. Stay calm. Stay polite. Use these phrases. Protect yourself legally. Print these out. Put them in your glove box. Practice saying them until they feel natural. Because in the moment when your heart is racing and the officer is at your window, you won't have time to think. You need these phrases automatic. This is educational content only, not legal advice. For specific guidance, consult with a qualified attorney in your state. If you found this valuable, hit that like button. Subscribe for more legal breakdowns that protect your rights. Hit the bell so you never miss content that could save you from costly mistakes. Share this video with everyone you know, your friends, your family, anyone who drives. Everyone deserves to understand their rights before they face a traffic stop. You just learned how to end a traffic stop in 2 minutes using 4 critical phrases, but there are other constitutional protections that apply during police encounters. And knowing when and how to invoke those additional rights can make the difference between walking away free or facing charges you didn't see coming. I break down those other legal frameworks and the exact timing for using them in the next video on screen. Don't skip it. It completes your legal education. The smartest people aren't the ones who talk their way out of tickets. They're the ones who know exactly what to say, exactly when to say it, and exactly when to stop talking. Stay protected, stay informed, and always plead the Fifth.